I'd like to bring up Amy Persails, Attorney Melissa Dixon, Attorney Bob Mannor, and Ina Golden. You're next going to be hearing from Attorney Melissa Dixon. She brings a wealth of knowledge to Mannor Law Group. She oversees much of our estate planning department and is an absolute rock star when it comes to probate and trust administration. After Melissa, you're going to be hearing from Amy Persails. She's our Planning Service Director at Mannor Law Group. She assists our families with finding and applying for benefits such as Medicaid and My Choice waiver. She has an outstanding record of helping our families, and in fact, she has completed over 600 Medicaid applications and has a 100% approval rate. So I'd like to introduce to you our team.
Good morning. I get to talk to you guys this morning about power of attorney documents. Can you hear me? Good morning. That's better? Okay, so I'm going to talk to you this morning about power of attorney documents. So every day we get calls from people in our office saying, my parents left me a real mess, and I don't want to do that to my kids, and so I need to come in and get a will and a trust. But at that time, they're often not thinking about power of attorney, or they're not aware of power of attorney. So after we educate them, a lot of times the focus shifts, and then we hear people say, well, can I come in sooner and sign my power of attorney? I'm going on a trip, or I have a procedure coming up, and so then they understand the value of those. So someone at the facility asked if I have powers, does this mean I need a cape? So that's just to visualize how, our agents or our people who step up and help others and act as power of attorney are heroes. I personally would love it if somebody came into our office wearing a cape. So what do I mean by powers? So there are two types of power of attorney documents, the first being the financial power of attorney, also known as the durable power of attorney. This is where an individual appoints someone, commonly a spouse or an adult child, who can step into their shoes and help them with their finances if they need them to. And that can include some of the things listed there: managing investments, paying bills, selling a home, and on and on. The other type would be the healthcare power of attorney, which is also known as the patient advocate designation. So this is where someone is going to step in and make a medical decision if necessary. And so the way I explain this to our clients is you're always in charge of your own medical decisions, as long as you understand what's going on. So if two doctors determine you don't understand anymore, then they're going to look to your patient advocate. Or if you're incapacitated or physically unable to make your own decision. So a well-written patient advocate designation or healthcare power of attorney is supposed to address end-of-life decisions. So if they're at the end of their life and they're on breathing machines or feeding tubes, do they give their advocate the authority to withhold or withdraw further treatment that could allow them to die? So they're supposed to list in the document specifically how they feel about that topic. So we're going to talk about the financial agent in more detail. So the fancy term for a financial agent, or the legal term, is an attorney in fact. And the authority is given by the individual themselves. So they get to pick who's going to make financial decisions for them or continue their finances if they need them to. So as an example, I appointed my husband. I am a little worried about that because I pay all the bills and do everything. He doesn't know what's going on, but I trust him, and I've given him lots of good backups, okay? So for our our clients, they come in and they'll say, well, I picked this child because they're the most responsible, or this one because they live the closest, or this one because they know the most about my finances. But the bottom line is that they're the ones granting the authority and picking the person that they feel is most appropriate for that position. And the amount of authority that they're giving them is in the document. So I wish I could give you the Cliff Notes or a shortcut, but I can't. You have to look into the document to see how much authority they're giving them in that financial power of attorney. So the goal would be that everyone would sign a financial power of attorney document, that they would take their opportunity to grant the authority. But if they don't and something happens, sickness, injury, or just time passes and old age, and now they're unable to handle their finances, we have to go to the court and request that the court grant the authority because they didn't sign a power of attorney. So in this situation, to give you an example, we had a conservatorship where the daughter just needed to get a life insurance form. She needed to fill out a Medicaid application, and she needed to know if this life insurance had cash value. So that's the only thing she needed, but she didn't have a power of attorney, so she needed the court to grant the authority. So we have to go through that process, that court process up there. It just depends on the county, it depends on the individual situation, but in all scenarios, we have to petition the court, we have to fill out lots of forms, and the court is going to appoint a guardian ad litem, which is their eyes and ears, somebody who's going to go out, do an evaluation, and then make a recommendation to the court on whether or not the court should grant or deny our petition. Then we're going to stand before the judge in a court hearing, and we're going to find out, does he or she grant or deny our petition, all of which can take 1 to 2 months or maybe even longer. So now we need that form from the life insurance company, and we have to wait until we get permission from the court to continue acting. So it is a resource. We use it all the time. We can go to court for conservatorship if we need it. It's just that it can be avoided. We can sign a power of attorney, a financial power of attorney, so that we don't have to request the court's permission if that situation ever arises. So not all superpowers are the same, and so when I said I can't give you a shortcut, you have to look at that financial power of attorney to determine how much authority has been given. This is what I'm referring to. So some of the distinctions or some of the things to look for in a financial power of attorney, some documents are springing, and so what that means is they're not effective until the person is unable to act for themselves. So they would need 2 doctor notes before they could begin acting. So they need that document from the life insurance company, but before they can get it, they have to go out and get 2 doctor notes saying that the individual can't do it themselves. So it's literally like putting 2 hurdles in front of them, and they have to go get those before they can act. That's why we prefer the effective immediately. So if it's effective immediately, they're already picking somebody they trust, and it says as soon as the need arises, they can begin acting. Some other distinctions, there's specific versus general. So a specific financial power of attorney may say, if something happens and I can't act for myself, then you can specifically continue accessing my bank account and pay my bills or sign checks, or you can manage my real estate, or you can run my businesses, but they're limiting them to something specific. Versus a more general document, and this is what ours look like, there's a paragraph in there that says, well, we have about 8 pages of examples of things they can do financially, but they're not limited to that. So they can step into my shoes and they can do anything that I could do for myself. So they have general authority to do whatever is necessary. And then we have extraordinary powers, so these are very cool. I'm sure you guys can appreciate as well as us that things change, and we don't know what's going to happen from day to day. So our clients come in, they're healthy, they're doing well, a lot of them, and so we put together an estate plan, we sign a trust and will and all the documents that we need, and then 5, 10, who knows how many years down the line, maybe it's only 6 months, something changes, and now that plan isn't sufficient. So maybe we need a different type of trust, or we need to protect some assets, or we need to qualify for Medicaid, and they're not able to come in and do that new plan. It is pretty extraordinary to say, I've put a plan together, this is what I would like to happen, but if for some reason it's not sufficient for me down the line and I need additional protection, I give the authority to my agent to come in and do that planning for me. So very, very, very important. Now we're going to shift gears and talk about the patient advocate. This is under a medical power of attorney. So that patient advocate is the fancy term for the person who's going to step in and make a medical decision if necessary. So again, they get to pick who's the most appropriate. So, I have people in my life who are wonderful and very special, but I wouldn't pick them because emotionally it would just be too much and they couldn't handle it. So they get to pick who is going to be able to step in, hear what the doctors are saying, understand everything, and make a good decision, make the decision I would have wanted them to make. So a lot of times they pick the child who already works in the medical profession or who's already been running around to the doctors with them and understands everything. But again, they're granting the authority. They're only going to come into play in that scenario where they're incompetent or they don't understand or where they're physically unable to make that decision. And so when they do step into that role, they're going to make medical decisions and they can also make placement decisions. So there's something up there that says that they also that if they want the person to be able to make mental health treatment decisions, they have to specifically say so in the document. So in ours, we have a section that talks about mental health, and then our clients get to pick, yes, I do give that authority, or no, I don't, or what level of authority. So that should be in the document as well. So again, the goal is everyone, did you have one? It has to be one or the other, right?
I think POAs do.
Yeah, we always notarize them. We have two
Not
witnesses.
the healthcare, but the financial.
The financial has to be notarized, yes. Mhm. Okay, so then the goal would be everybody would sign. Who can make a medical decision for me if I'm unable to make it for myself, but if they don't and they end up sick and they can't call and get the forms and they can't, make a decision, whatever the case may be, we're in that scenario again. We have to petition the court. We have to fill out the forms. The guardian ad litem is going to go out and do an evaluation and make a recommendation, stand before the judge. Again, it's 1 to 2 months, maybe even longer that we could be waiting. So again, a good process, but we can avoid it by signing a medical power of attorney. And if they're given authority, if the judge gives somebody the authority to act as guardian, generally they're going to control everything, unless, of course, the judge limits their authority in some way. So other types of things that guardians can do, guardians can and probably should file for Medicaid. Our little recommendation for this one is to consult with an attorney, an elder law attorney, on whether or not they're eligible first, because Amy, I'm sure, encounters a lot of scenarios where people apply and get denied, and kind of keep doing this. So it's a good idea for a guardian to consult an attorney, an elder law attorney, regarding eligibility first. Guardians do not handle financial assets, so they only deal with the income portion, so just their monthly income. If they need to access other assets, they have to become conservator as well. The facility cannot be a guardian. That would be a conflict of interest, but they can request that the court appoint one. And they can sign a DNR, but if they were appointed as guardian prior to February 4th of 2014, they may need to request court permission first. So this is the most important slide, so if you started daydreaming about lunch, this is a good time to come back, okay? Testamentary capacity versus competency, okay? So in your scenario, you're going to encounter people probably every day that you would say they're not competent to make a medical decision. And so you're gonna look to their patient advocate if they have one, but you've determined that they can't make a medical decision because they don't have the ability to participate in the decision, they don't have the ability to understand, or the ability to take action for themselves. So in your scenario, somebody may not be competent, but that's very different than whether or not they have testamentary capacity, which is what we look at in determining whether or not they can sign legal documents. So the goal is that if you're gonna be dealing with medical decisions, that you can deal with the person directly, but if you can't, you want to be able to deal with at least who they would have picked, right? So that's where testamentary capacity comes in, is we want them to be able to sign documents saying who's going to step in and make a decision for them if they can't make it for themselves. So to determine whether or not they have testamentary capacity, I'm going to share a story with you on something that happened to me and Amy a couple of years ago. So we had a client. He already had powers in place. He already had his daughters listed in a succession to be able to step in and make financial decisions. And the document was lacking that extraordinary power. And it wasn't the latest and greatest, and we wanted to make sure he had the maximum protection. So we said, let's go out and meet him at the facility. We'll sign some new powers. We're not going to change the agents. We're not going to change the order. We just want it to be the best document with those extraordinary powers with the most protection. So we went out to meet him, and I sat down with him, and I was chatting with him for about 10 minutes or so before the nurse recognizes what's going on, and she came in and said, excuse me, I need to speak with you, please. And she takes me out in the hallway, and she said, he's not competent. He's been determined not competent. He can't make his own medical decisions, therefore we can't allow you to proceed. And so I was really stunned, and I was like, I'm going to need to phone a friend. So I had to step out and call Bob and say, Bob, I've just been booted out of here. What do I do? And he said, she's doing exactly the right thing. She's advocating for her patients. She's doing nothing wrong, but there's this difference between competency and testamentary capacity that I'd like to explain to her if she's willing to have a conversation with me. So they chatted for a few minutes, but the difference here is competency. She said he's getting confused. He ends up on the wrong floor. He thinks that one of these nurses are his friend. They have lots of really great reasons for why he wasn't competent to make a medical decision. That's very different than the conversation I had with him. When I sat down, I said, we're here to sign power of attorney. Do you know what that is? Oh, absolutely. My daughter is helping me, and I need that to continue. And I said, oh, no, we're not going to change it. And he said, I want this daughter. She's always been helping me. She's taking care of my house because I can't be there right now. She's also taking care of my taxes and all this other stuff. She goes to Comerica. All the ladies down there know her. I don't want that to change. And so I knew in that conversation, he knew who his kids were. He knew what his assets were, and he knew that he couldn't take care of those things, but he wanted someone else to be able to do it for him. And so the difference there on that very last line on that slide, that he understood that he was granting the authority to someone else to do certain things, that he had assets, and he understood generally what he was doing. And so it's a much lower threshold, and it's very different than what the medical professionals are going to be looking for, okay? So how can you use this info to help your residents and patients? I'm sure you encounter people every day that probably don't have power, so it would be a really great idea to point them in that direction. If they don't have somebody, even if they're making their own decisions right now, and we know people come in and out of capacity sometimes, or competency sometimes, if something happens and they're unable to make a decision, we want to make sure they have powers in place. So if they don't have them, you can recommend it, and if you're not sure about that testamentary capacity, remembering it's a much lower standard, it never hurts to have an attorney do a review of that, okay? So what if there are no agents and we need immediate action, so we don't have power of attorney documents and we're unable to sign them? We have a couple of other resources at the court we can use. We can apply for an emergency guardianship. This is saying, okay, court, we don't have 2 months. We need an answer. And they're going to put somebody in that position temporarily, and then we'll go back and do the full process to determine who should be in that position long term. And then we can petition for instruction. So that's another resource to say, this is our problem, you tell us what to do. So the court can give us an instruction, and then it reduces the liability on you guys. So what if they're, if they can't appoint someone, and we don't have any time for any of those processes, so we have no powers and we don't have time to go to court. There are some, we have some legal support that would authorize a family to step in, an amicable family, in an emergency scenario there where you have terminal illness, someone in a nursing home or on Medicaid, that the family can make a decision in that situation. So that's it. It's been fun. If anything comes up, there's our contact information. Please reach out.
Before Amy talks about Medicaid, I want to throw out a little challenge to you. So how many of you have made your own determinations as to, if you couldn't make your decisions, that you've got somebody set up who would do that for you? And you, not just you have it, but you have it in writing. It's a legal document, powers of attorney, healthcare documents. If you're over 18, you should probably have that. If you're under 18, you don't need it yet, but if you're over 18, you should probably have someone, a legal power of attorney, a legal healthcare advocate, a HIPAA waiver. Those are things that are very important. And secondly, is that if this is something that you're dealing with clients on, this is probably the main topic. We do lots of lunch and learn. So at the end of the presentation, or at the end of the day today, we're going to talk about if you want us to come to your place of employment and do a lunch and learn for the employees and things like that, we can do that. The biggest topic usually we're asked to talk about is substitute decision making. Who can be the decision maker when someone has dementia or someone has Alzheimer's? And the question is, you know, this is something that you're probably dealing with from time to time. whether the family can make decisions, you're going to be a lot better suited to be able to do that if you've gone through that process yourself to figure out who is it that you would want to be able to make those decisions. And so it is something that we do. And so I would strongly recommend, if you don't have it, feel free to call the office. We'll make sure that we'll get you in and get those lifetime documents for you and your spouse if you're married. It's important that we have both, that everybody has those. I call them the lifetime documents. If you don't have it, we end up going through a court process. And so the court process isn't always as smooth as you'd like it to. Most of the time we want things to stay in the family. So if we can keep it out of the court process, keep it out of the government process, anything can happen to any of us. I was looking for the youngest person here earlier. It doesn't matter how young you are. Anything can happen to any of us. And so if you don't have these, we'd be happy to help you get those. So.
Okay, let's talk about Medicaid. So the first part I want to bring up are the Medicaid musts. So meeting the level of care, the doors Bob talked about earlier with you, the 8 doors that everyone has to qualify under. So whether it's long-term care Medicaid in a nursing home, My Choice Waiver, or the PACE program, everyone has to qualify under one of those doors. They need to be, if for long-term care Medicaid, they need to be already living in a Medicaid licensed skilled nursing facility. So that is another absolute something that has to happen. So they can't be at home wanting to transition to a long-term care facility. We can't apply for Medicaid until they're actually in the facility, okay? We can't make them Medicaid pending before they come to the facility, unfortunately. They have to meet the asset and income requirements. So as far as that goes, we can work with them to try to make sure that the qualifications there, getting those things done. I did want to also bring up, Bob had talked about the PEME earlier, the pre-existing medical expenses. That only works to go back the 3 months prior if they have a patient pay amount. So sometimes if there's a married couple, there's no patient pay amount. That requirement is there for that. You cannot get that pre-existing medical expense if you do not have a patient pay amount. I get a lot of that from clients telling me that the nursing home said, well, we can go back 3 months, we can go back 90 days. Well, you don't have a patient pay amount. We can't do that, unfortunately. So income requirements. Skilled nursing facility, income must be less than the cost of the care. Okay, pretty simple. Patient pay amount is their income less. They get to keep $60, $2 a day. And they also get to keep paying their health insurance premium. So if they have Blue Cross, HAP, any of those extra coverages for the Medigaps, they can continue to pay those coverages. So that's deducted before their patient pay amount is calculated. For My Choice Waiver, the monthly income must be $2,313 or less. As Bob talked about earlier, if it's $1 more, then they don't qualify, unfortunately. And that for their patient pay amount, there's no patient pay amount. There's a stipulation, though, unless PACE is covering their room and board. So that could be something else also. So asset requirements for a single person. They must have less than $2,000 when the application is submitted, okay? Their assets could be any of these items. They could have bank accounts, CDs, annuities, IRAs, any of those types of things. Life insurance policies, we'll talk about that in a minute and what that requirement is. But vehicles, so they can have one vehicle, which is an exempt asset. Doesn't matter if it's a Lamborghini, can be whatever you want to have. But one vehicle is always exempt, okay? They can have a house and property, the adjoining property. As long as it's adjoining, it's exempt. So there is a limit. It's around a little over $550,000. So you can have a $500,000 house and a Lamborghini, and you can keep those things. So hidden cash. This is one of the things we've ran into in the past where clients, I have to specifically ask them, do you have money under your mattress? Do you have money in a safe deposit box? I had a gentleman come in one time and told me absolutely not. He had nothing, right? Everything he gave me, he gave it all to me. A week later, I met with him to sign some more documents and go over some things, and he sat down and he said, I haven't slept in a week. I have to tell you something. And he said, I lied to you. I had money stashed away. And I said, well, I'm really happy to know that you haven't slept in the last week because you felt bad about that. So I said, what did you do with it? I put it in the bank. Okay, great, perfect. So we need to know. We don't, as Bob said earlier, we do not hide assets. We want to make sure that everything is accounted for. We can't help protect it if we don't know about it, okay? Exempt assets, like I said, house, one life insurance policy with a face value less than $1,500. So if you have a life insurance policy that has a cash value of $6,000, but a face value of $500, it's exempt. Okay, it doesn't matter what that cash value is, as long as the face value is less than $1,500. And then one vehicle. Prepaid funeral and burial funds. So the prepaid funeral, though, has to be irrevocable. Adam Martin is going to talk to you about the qualifications for that in a little bit, too. So, but it has to be made irrevocable. A lot of people will tell me, I have a prepaid funeral, and then provide me with the documents, and they're not irrevocable. So the next is we talked about this a little bit earlier. I just want to bring it up one more time. You have this, it's laminated. You can use a washable marker, write on it when you talk to your clients. We have more. I have some up at the Mannor Law Group table. So if you need more, you have someone else that you want to give some to, and you can also call our office and we'll mail you some. So just let us know if you ever need more of those. And we come up with them. We come out with them every year. So I have a case study with Rose. Rose is 85 years old, and she needs long-term care. She needs help making some decisions, but still can name all her children and identify her assets. She has $1,200 in the bank, no house, 2 life insurance policies valued at $20,000 each, savings bonds, about $18,000 worth, and an annuity worth $37,000. She only receives Social Security, no pension. She has no power of attorney documents. And she has 2 great daughters, Sarah and Denise. So typical advice that she would get would be to spend down to $2,000.
Well, Amy, before you go on
Yes.
that, how would this family present to you? If they came into you and they talked to you, what would they say about Rose? Rose has nothing.
Right.
She has nothing.
Absolutely.
She has
Absolutely.
$0.
Yes.
She has whatever's in her bank account.
Right,
But
right.
when you look at all the hidden assets, she's definitely not going to be eligible for Medicaid without some planning. So.
Well, and one of the biggest things that I see are the life insurance policies, okay? Most families think they're exempt just because it's life insurance. It's there for your funeral, right? To pay for your after-death services. And so no one ever thinks about life insurance as a asset. It is life insurance. That's what it's there for. I have had a lot of people tell me they don't have anything. Melissa stated earlier about the family that came in that needed help trying to determine whether a life insurance policy had a cash value. Well, it did, and the family thought it didn't. They thought there was no money. So we had to help them with Medicaid planning because they thought they already qualified. So the typical advice, again, is spend down to $2,000, then apply for Medicaid, okay? The problem with this is Rose has a diminished capacity. There's no money at that point. There's no authority. Now the court must be involved, so we might have to get a guardianship, and then we have court involvement, and they rule the roost. They tell you what you can and can't do. If funds are low and time is needed, facility runs a high risk of not getting paid. Remember, that life insurance policy. What if we don't find out more about that? Medicaid approval is a waiting game and a good chance of denial with no chance paying. So our advice would be to obtain a power of attorney with long-term care planning permissions, so that those extraordinary powers. This is not an online form. Please do not go online and try to pull your own power of attorney document and print it out and fill it out yourself. Refer to us to do the Medicaid before all assets are depleted. Again, we just never know if there's another life insurance policy out there that we didn't know about. And then something happens and now we need to pay a month at the nursing home. And we have no money because we've spent it all. Oh, sorry. Thank you. Sarah, as one of the daughters, if we sign the the power of attorney, she has the ability to assist, even though Rose is diminished capacity. Court is not needed, facility gets paid, and being proactive is avoiding unnecessary issues. So if you send them to us before all the assets are depleted, we can help make sure that things are done properly and correctly. So Bob talked about avoiding the in the red bed earlier. So making sure that you get paid. That is my ultimate goal, trying to make sure that the facility gets paid. And, that's one of the biggest things is it's really upsetting when they don't, when we can't get you paid because of unforeseen circumstance. The family didn't tell us about something, or they didn't know about something, because that happens, unfortunately. Melissa talked about the guardianship and the guardians applying for Medicaid. We had a circumstance where there was a guardian and there was a nursing home, and the bill was upwards of $80,000 by the time we were involved in the case. And they came to us, the family came to us and said, this is not working. Something is not right here. Well, they were right. There were a lot of things that were causing this Medicaid application to not be approved. The guardian she said she's been processing applications for over 30 years, but she never ran into anything like this one before with this family. So you just never know. Having someone take a look at it, making sure is always a good idea. So asset requirements for a married person. So spouse is applying for Medicaid. And the spouse that's applying for Medicaid can only have $2,000 when everything is said and done. We do have a 12-month grace period to transfer assets to the healthy spouse, okay? So we can get everything, them asset eligible, and then we have 12 months to make sure everything is moved around properly and that the healthy spouse gets all of the assets transferred over. The community spouse, or the healthy spouse, can keep the lesser of half of the combined assets that either spouse has an interest in, a maximum of $126,420. That number changes every year. Minimum community spouse resource allowance is $25,284. So if I have a client that has $50,000, they can keep $25,284. If I have a client that has $100,000, they can keep $50,000, okay? And this is, this number, the minimum community spouse requirement is also, it changes every year. Goes up really, really small increments, okay? So it doesn't help much. So where those numbers come from are the snapshot date. Or it could also be called the initial asset assessment date. So the IAA date, initial asset assessment date, snapshot date, is the first date of continuous period of care that the Medicaid applicant spent 30 days or more in the hospital or care facility. So Mr. Smith breaks his leg and goes to the hospital. So he is in the hospital on January 1st. 2 weeks later, he goes to a rehab facility. He's there for 30 days, okay? So for that time frame, when he goes back home at the end of February, he has now been in about 60 days of continuous care, okay? So he's got his 30-day snapshot date, which is January 1st, the first day he went to the hospital, okay? And that is the date that you get all of the assets from. So if that date was January 1st of 2012, you need all of the assets from January 1st of 2012. And today is, May of 2019. And so maybe they probably, feasibly, had a little bit more money back then because they've had some health issues and things like that. So maybe they had $300,000 back then. Now they can only keep $126,420 of that. We can help plan to keep everything. But the idea around that is that they can keep it. They can keep more money that way. So we talked about a house being in a trust. If a house is in a revocable trust for a married couple, it's actually a great thing. So that lets us keep more assets that way, okay? So just so you know, when you have a client or a patient come in and you see they have a trust, don't send them to an attorney right away necessarily to get the house out of the trust, because we may want that house in the trust to be able to apply for Medicaid later. We'll take it out when it's time to apply. It has to be taken out to apply. It's not exempt in the trust. So while we're talking about deeds, ladybird deeds. Everyone, I'm sure, has heard this term, ladybird deed. Everyone thinks they have a ladybird deed, and they can also cause more harm than good if not done properly. They could have two names on them. They could not be an actual ladybird deed. Maybe the family thought they were getting a ladybird deed, and it's not actually fit to, a ladybird deed. So you want to have an attorney look at that over just to make sure that it's properly completed. So a state. Oh.
Okay. Yeah, a ladybird deed is kind of like a contingency deed. So what it does is it says that the person who owns it will continue to maintain all rights to it, but that if they haven't sold it or transferred it or mortgaged it or anything like that prior to death, upon their death, it transfers. So it seems like a fairly straightforward transaction. In practice, it can get very, very complicated. People can die in the wrong order. There might be too many people on the deed. There's a variety of reasons why the ladybird deeds sometimes are, it's not just a blanket solution, but that's basically what it is. To whoever is on the other end of the deed. So often it's going to be the kids, but that's sometimes can be problematic because it doesn't create the solution that the parent wanted. The house doesn't end up where they expected it to end up, and so it's just one of those things that we have to look at whether this is the best solution or if there's better options. But that's basically it. It's almost like a contingency deed.
Thank you, because I know you.
Sure.
Please.
Sure. No,
Yeah.
your problem. Thank you.
Yeah.
So estate recovery. So estate recovery for Medicaid. So we already said you can keep a house and a Lamborghini. So if you have those things, then they could be subject to estate recovery. And so you get to keep it exempt for Medicaid if you can find someone to help you pay the bills, right? Because you only get to keep $60 a month. But you may have to give your house away at the end after everything's said and done. The state may come in and take it back from you because of estate recovery. They've paid your bill at the long-term care nursing home for the last 6 years, and now they want their money back if they can get what they can. So you want to make sure that there is no estate recovery. So maybe there is a deed that needs to be taken care of beforehand, before your patient passes away. So asset traps. So parents' names on kids' accounts, Bob talked about that a little bit earlier. That's not a good idea to have your parents' names on your accounts. They are accountable asset. The applicant's name's on the parent's house. I had a 90-year-old client, or I'm sorry, 90-year-old mother who had her 85-year-old or 80-year-old daughter, I guess she was, right around there anyway. The daughter was on the mom's house anyway. And, son-in-law was in the nursing home. So we had to figure out how to, take care of all of that. So sometimes you don't think about it. They do it for purposes of helping their parents out or things like that, and it can actually cause problems. Patient prepaid for nursing home stay. Can't pay for next month at the nursing home. It's a countable transaction. IRAs, if a person is incapacitated, must have a power of attorney to access. House in the trust is a countable asset. Ladybird deeds may be a divestment and cause penalties. So annuities, the state of Michigan must be the beneficiary to extent of Medicaid payments, and that's if there's no spouse. So if the spouse can be the first beneficiary, but the state of Michigan has to be the contingent beneficiary on any annuity. So penalty periods for divestments, if you give away $8,469, you get a 1-month penalty at the nursing home. So for every $8,469 you give away, Medicaid will not pay for 1 month of your long-term care. And then gifting, this is the part of the Medicaid application that asks you about the gifting. So have you given away any money? Innocent transfers, forgiving a debt, bad advice, selling something for less than fair market value. All of those things can count against you. So you give away a car, sell your car for $1,000, but it's really worth $5,000. Those are problems.
Advice from the neighbor, advice from this is the way Aunt Susie did it, so you should be able to do it too. It could be, one of the very frequent things is I call it the barbershop advice. I was literally in a barbershop one time, and one of the patrons was saying, I'm not sure what I'm going to do about Mom, and the barber said, don't worry, just take all of her money and put it in your account and everything will be fine. It doesn't work that way.
All right, so what happens if they sell the house? There could be consequences of selling the house after Medicaid's already been approved, depending on the situation. So if it's a single person, obviously they've just gotten a big, huge pay load, right? Healthy spouse dies first. We've seen this so much lately. Medicaid spouse receives an inheritance, so life insurance policy, any of those types of things. So when it comes to the redetermination, married couple, Medicaid spouse's assets must be below $2,000. So when it's time for redetermination, they have to be below that $2,000 threshold for a married couple. And then estate recovery. So obviously, we don't want the house that we've protected and kept all these years to go to the state. So now we have John and Mary. John's 73, Mary's 67. John was a veteran. Mary's healthy. John recently had a stroke and needs 24-hour care. So they have a house, some IRAs, life insurance policies, checking and savings, and they also gave some money to their son of $10,000 a few years ago. So they have $50,000, roughly, in countable assets. But that $10,000 they gifted to their son is also countable. So they have $60,000 technically in countable assets. So they spend down to half. They have $30,000. Mary and John get to keep 20 because obviously that $10,000 doesn't really exist anymore. And there's no planning for Mary. So without planning, they have $20,000 left over. That's not very much money for Mary to live on. The house is unprotected. Mary has $20,000. Medicaid's denied after the first year because assets were never moved. Because you do the application but never got the right advice of what to do next. Medicaid denied if Mary dies first. So maybe something happens to Mary and the money is still in John's name. So he has $20,000. With planning, the $60,000, the son signs a promissory note to return the $10,000. Medicaid planning is done for the other assets for Mary. They get to keep the house. Mary will get to keep all the assets when we move everything over to her name. And John is qualified for Medicaid and remains qualified for the next year. And we make sure that we have the planning in place for Mary.
So we are here to help. Honestly, if a family says the word Medicaid, can't hurt to send them our way. If they're thinking Medicaid, we do have, I know sometimes people will ask about our fees. Well, how much is this going to cost? Well, we do now often do just a consultation, just a 1 hour or 1.5 hour consultation, and that might be all they need. It might be that we just need a ladybird deed. It might be that they just need that. Now, a lot of families, once we get into it, we're going to find out that, oh, there is that life insurance policy, there is this other thing. So pretty much if they say the word Medicaid, we're happy to have you send them our way, even if it seems they have no assets. I understand that a lot of families aren't real thrilled about the idea of going to see a lawyer, but the reality is most of the time we're going to make it so that whatever our fees are going to save them money. It's whatever is paid to us, they will have lost that money many times over again if they didn't get proper legal advice. So we're going to move on to the issue of veterans benefits. As many of you know, this has changed quite a bit in the last little bit, and so I want to first talk about the issue that you're probably a little bit familiar with, which is the aid and attendance benefit. So what hasn't changed is the qualifications here. So they still have to have served during a period of war, and so we have the periods of war listed here, and so just have to have served at least a single day during one of those periods, have to have served a total of 90 days, have to have a discharge other than dishonorable, so a medical or general discharge, and have to have unreimbursed medical expenses that come close to or exceed their income. What has changed is the asset requirements, okay, and this is significant. Now, you may have heard that these changes are really bad. They're not. They're good for some people. They've really made it so more people can be eligible, but they've made it more difficult to do planning. These benefits can help pay for independent living. It can help pay for assisted living. Is it going to pay enough to pay for assisted living? No, but that plus their Social Security check, that plus their pension, it might be able to make it so that we're not burning through their money so quickly. And then, of course, it can pay for in-home care. It can even pay for home care from a family member. If we're going to do that, though, or if we're going to do any kind of in-home care, unfortunately, the Medicaid rules now require us to have a notarized care contract. So you just have to be careful on that. So the breaking news on veterans benefits is that they've changed the rules as regards to assets. So you may have noticed there's not as many people coming around offering to help people with veterans benefits. Why is that? Well, I've been telling you for the last, how many years have we been doing this? 5 years? That most of those folks out there had financial products that they were selling, and they were high commission financial products that they were selling. And based on these new rules, they can't really do that anymore. And so they're not, it's all about the money, right? And so if they can't sell their financial products, now I've heard through the grapevine that some of the groups are out there saying, oh, you simply can pay us a membership fee and we'll still take care of your veterans benefits for you. That's probably illegal. The rules are very clear that no one can charge a veteran any money for helping them fill out a veterans application, submitting a veterans application. So no one should be paying money for help filling out the veterans applications. Now, what are the asset requirements? Well, now it's a house plus 2 acres. So what if you have 4 acres? Well, then the other 2 acres will count. We have to evaluate what's the value of those other 2 acres, and it'll count towards the other assets that you can keep. There are some rules that we're going to be able to flesh out as time goes by, where it says, well, what if that means that that property is going to be landlocked if we have the house and 2 acres? Well, there's going to be some rules we're going to flesh out. Bottom line is, in a year, we'll probably know a little bit more about some of the planning options that we have, but nobody really wants to be the guinea pig. Nobody really wants to be the one that tests the VA on this, but somebody will be out there, and in a year, we'll probably have more options to say, well, what if it's 3.5 acres, things like that. But the basic rules are a house plus 2 acres. You can have up to $127,061. That's adjusted for inflation. Now, many of you may have heard that number now lines up with the Medicaid number for a married couple, and it did last year, and now it's divergent. So they can never make anything simple and keep the same numbers for both programs. For 1 year, they matched up the Medicaid number and the VA number, and then they said, but the VA number is going to be adjusted for inflation, and the Medicaid number is adjusted for this other formula, and so it no longer matches. And so that same, it is the same number whether it's a married person or a single person. So a single person can have $127,000, a married couple can have $127,000. They say that you must add in their annual income. So if they make $40,000, then you'd subtract $40,000 from the 127, but that's not really correct because they can subtract your medical expenses or your long-term care expenses from your income. So if their home care costs or their assisted living costs is more than their pension and Social Security, then we don't have to add anything in that. The VA defines income as income minus unreimbursed medical expenses like home care, long-term care, assisted living, any of that. And then the big rules are there's no gifting anymore. You can't transfer assets and they will penalize you. The penalty is pretty severe, though. With Medicaid, there's penalties with regard to Medicaid, but they'll penalize you for every 8,600 and some that you transfer. What is it, 8461. With VA, they penalize you for every 2,200 that you transfer. So the penalty, you can rack up a huge time penalty with even a small amount of money transferred. However, they did grandfather us in. So anything that occurred prior to October 18th of 2018, they're grandfathered in. So we don't care about at all gifting if it occurred prior to that. You just can't do it now. So really it's more of a look forward than a look backward. But come 5 years from now, we're going to say if you've transferred assets in the last 3 years. One of the key issues on this now is with veterans benefits and why they probably need to consult with a lawyer or somebody that's knowledgeable about this is when you file is very important. If you file and there's going to be a penalty, we probably should have resolved that penalty or cured that penalty prior to filing, because there's going to be some deadlines and some rules as to when you file can have a significant impact on whether you're going to be able to get these benefits or not. And then the big thing was no annuities. So if the family has annuities prior to October 18th of 2018, they're fine. But if they can't purchase an annuity with the idea of that's going to help them qualify for veterans benefits. This was the main reason why they've made these changes, right? This was the VA and AARP and several other groups basically felt that financial products were being sold to veterans or their spouses that were inappropriate for people their age because of the commissions that were being given to the people that were selling them, and so the changes were basically to shut that down. Now, why is this potentially good news? Well, because before this, sometimes people with $50,000 would get denied benefits. Sometimes people with, minimal, not that many assets. Now we have a clear, bright line that says if you have under $127,000, so what if they have $150,000? That's fine. So within a few months, for at least within whenever they spend down to $127,000, they should apply. And so it opens it up to a lot more people, a lot lower income, a lot lower asset people who are going to be able to be eligible, and there's a little more of a bright line rule. So it's going to be, should be, obviously whenever there's a change, there's going to be a backlog in the government processing of it, right? But in the long run, this should be easier to get veterans benefits for people that are eligible, people are within that time frame. One of the things as far as planning for it, so often people will come to a lawyer to say, well, I want to plan for it, I want to protect those assets. Well, if we want to do that, if we want to use trusts or anything like that to plan for veterans benefits, this particular veterans benefit, then we'd have to do it 3 years before we think we're going to need to apply. Okay, so sometimes that means maybe buying some long-term care insurance or some other factors in that. But those are the big changes. It's really a 3-year look forward. These are the monthly rates, so this is for 2019. You have that in your materials, and that goes up every year. Just give you a quick example. This couple would run out of money with their income and their costs at the end. They have independent living with some additional expenses. They start out with a house of $120,000. They'd run out of money in 5 years. But if we get the benefit for them, then after 5 years, we still have $100,000 left. So they'd be able to stay in independent living, stay in assisted living, stay in home care a lot longer. It's going to leverage that money. So don't let anybody tell you that veterans benefits is dead. Okay, it's definitely still out there. There's still going to be other planning techniques that we're going to be able to use. We're going to have to kind of, unfortunately with the VA, it's a trial and error kind of a thing. So we're going to have to kind of test the VA a little bit. But in a few years, in a year or two, we should be able to know exactly what we can do that's still going to qualify under their rules. Okay. But really, I want to focus a little bit different. There's misconceptions. You don't have to have served in combat. You don't have to have gotten hurt during combat. What I really want to focus on now is, well, before I do that, let's talk about some of the handouts that you have in your materials. Many people, veterans will say, I lost my discharge. How do we find it? We found the most useful one is the Michigan Veterans Form. So that's in your materials. And so we find if they were a resident of Michigan when they got out, they can get it from the Michigan veterans, because the VA will often say they lost the form. They lost it in a fire, right? So if you go through the Michigan veterans, they almost always have it. If they weren't a Michigan resident, then you can go through this other form, so we gave you that too. There's the healthcare enrollment form that we've provided you, and the pre-burial form if they want to be buried at, them and their spouse want to be buried at the National Cemetery. But one of the things I think that we really need to focus on, and I've been talking to attorneys about this for the last several years, this is going to be our population soon, okay? We're dealing with a lot of Korean War vets and World War II vets and things like that, but pretty soon, if we're going to stay in the industry, if you're going to be around for the next few years, we're going to see more and more Vietnam-era veterans. And there's special benefits for Vietnam War era veterans that are going to be that aren't really available to other veterans, and at least particularly when it comes to the issue of presumptiveness. The presumptiveness is really important because anybody that was injured during service can get these benefits, but it's very difficult to prove that causal link between service and whatever disease they're suffering from. But they've made it a presumptive causal connection for anybody that was in Vietnam and some other things that we're going to talk about. So I'm going to have Ina speak to that. Ina is a Vietnam-era veteran. She was in the Navy, and she is soon going to be a chaperone on an honor flight.
A guardian.
Guardian on an honor flight. So I'm going to have her talk to you about the presumptiveness.
Thank you. Thank you very much. Also, in addition to working with Mannor Law Group as their nurse, I am a volunteer and I'm secretary of the Holly Area Veterans Resource Center, and that's the guys over here in the corner over here. You can talk with Paul and Ray more later during lunch and afterwards. So I'm going to talk about presumptive disability benefits, and so what I'll discuss is what are they and why Vietnam and why the Korea DMZ, or the demilitarized zone. Whom does it affect? What is the list of illnesses? How to begin the claims process? What will you need? And then I'll sum it all up. So what the VA defines as presumptive illnesses is that it presumes that certain disabilities were caused by military service and the veteran can be awarded disability compensation. Interesting with Agent Orange that this is years later that they have attributed Agent Orange to a lot of the disabilities that many of the veterans had when they served. The final recognition of Agent Orange took effect October 30th, 2010, 35 and a half years after the war ended. And it went on for a long time, as you know. Agent Orange was the combination of two herbicides that they used as a defoliant. What it did is it knocked the leaves off the trees, and it also took off the ground cover. And we did that over in Vietnam so that we could see the enemy. We didn't learn until many, many years later that this was a poison, a horrible poison that got into people and affected them for many, is affecting them now. 20% of the country of Vietnam was sprayed with their land and water all over this to destroy the foliage on the trees. 3 million U.S. military personnel served in Vietnam with what we call boots on the ground. So why do we call it Agent Orange? What is this agent thing? Well, in the military, we like to do things kind of simply, and Agent Orange meant that it came in orange barrels. Now, there were some other colors eventually that it did come in, but most of the time that you would see orange barrels, then they said, well, there was Agent Orange. So it's a combination of 2,4-D and dioxin 2,4,5-T, and I don't remember all of those that it applies to, but it came in those barrels, and it was the combination of those, and it was a poison that dropped the leaves. And I guess because I'm a nurse, if you kill these living things, what else are you killing that's living? So what do we have now? Well, it doesn't affect everyone. There's a lot of factors that go into effect for this, such as genetics, your immune system, the amount exposed, and the concentration of the amount that you had. And if you were in Vietnam 1 day, that's all it took, 1 day, and later you developed certain conditions, even decades later, you are entitled to disability compensation from the Veterans Administration. And I'll tell you later why it's so important for you to take this back to your facilities and to the people that you know, because there's some few little glitches in the government. So, what areas am I talking about? Well, there are a few others, but the main ones are Vietnam and the demilitarized zone of Korea. You can see that DMZ there in Korea. And the dates. The dates for Vietnam are January 8th, 1962 to May 7th, 1975. And in Korea, this is after, most of the combat in Korea stopped in 1953, but we're still dealing with Korea now, as you know. April 1st, 1968 to August 31st, 1971, they sprayed the DMZ. And there were people with boots on the ground then. So you can see these dates. That's part of your handouts that you have. So I guess because I'm Navy, I was real interested in this. Now, I was not in Vietnam. I was on the other side of the world. And I'm very grateful for that. But for those that were, they need to be compensated. And so with the Navy, brown water Navy was included. When I say brown water, that's up in the streams and in the rivers of Vietnam. And if you were remembering from the Vietnam time, they talked about the PT boats going up in the rivers. But what about those that were in the ships off the coast of Vietnam? Are they counted too? Because they were finding that a lot of these sailors were having a lot of these presumptive illnesses, but they were not counted. It was only boots on the ground. Well, I'm happy to tell you now that as of January 2019, yes, just a few months ago, that they determined that those sailors that were within 12 miles of the coastline, and if they have these presumptive illnesses, now 190,000 more sailors are eligible. That's huge, and that's a lot of people in your facilities as well. So you're saying, how come, what's the 12-mile thing, and they're out in the ocean, and here you're talking about in the ground, but what is that all about? Well, that's because on the ships, they take seawater and make it into fresh water. And the herbicides, with the rains and all, washed into the sea. And when they took that and made it into fresh water, it had the contamination of it. But they used it for drinking and showering and bathing and washing dishes and different things on the ship, and those sailors were also contaminated. The VA is not expected to appeal this, but it did come down in the courts and for January 2019. So I bet you're wondering, what are all these presumptive illnesses you're talking about? Huge things that a lot of your people in your facilities have. Type 2 diabetes and ischemic heart disease, huge, and a lot of people have those. And it is attributed to the Agent Orange when they have it. And then not just type 2 diabetes, but some of the complications that can affect them, such as neuropathy, and how the VA looks at that is, okay, what extremities do you have neuropathy with? You have it in your left arm, you have it in your right arm. Is it, or your left hands and right hands. Is it mild, moderate, or severe? And by that, they determine your compensation for that. Erectile dysfunction as a complication of type 2 diabetes can also be compensated from the VA. And when I say ischemic heart disease, that means that your heart's not getting enough blood. You don't have to have full-blown congestive heart failure for this. You just have to have a heart that's not working properly and needs more oxygen. Parkinson's disease is another one, and a lot of cancers. Leukemia, the blood cancers, prostate cancer, and then a lot of the respiratory cancers such as lung, larynx, trachea, bronchus, and then also cancers such as sarcomas are as well. Now, I know you can't read this. It's really, really small, and we were hoping to have some VA packets here, but our representative's aide didn't make it in time. But you can get these from your representative in Lansing and say, hey, I need that VA packet. And it'll show these presumptive illnesses. Now, the gray areas talk about a lot of the different cancers and ischemic heart disease, but I want to call your attention over to the right side, which is orange. And it shows that any man who had a child after he was in Vietnam that had a cleft lip or a cleft palate, that child is entitled to compensation. And then any woman who served in Vietnam and had a child with a cleft lip or cleft palate, or all these other ones going all the way down there, down that list, those children are also entitled to compensation. And some of those are cleft lip, cleft palate, congenital heart disease, a club foot, hip dysplasia, Williams syndrome, which is a chromosomal abnormalities, fused digits, pyloric stenosis, and several more that you can see that if you have children that had their mothers who were in Vietnam, and all it took was 1 day in Vietnam also to have that compensation. So what do I want these people to do? To see an accredited service officer. We're real fortunate here in Holly that our service officers who are down at the county courthouse complex come 2 days a month to Holly, and we see a lot of different people. A lot of people don't want to drive down in the city. A lot of the newer veterans don't want to go into the city areas or under underpasses, and a lot of the old guys don't want to go and try parking and try to find out where to go. They can come to our center here. It's the old high school. And you come in, the coffee pot's on, and we tell a lot of stories. These guys can attribute to that. Am I right, Paul? Yeah. Okay. At Oakland County, there's the address there, and in Genesee County, I also have the address. Oh, the other thing in Holly is that it can be for Genesee County or Oakland County the third Monday of the month from 5:30 to 7. We have a program called Vet to Vet. We also have a guy there from VBA, or Vietnam Veterans Association, from 11 a.m. to 7 p.m., and he can fill out the forms as well. His name is Lee. In my opinion, it is unethical to charge a veteran to fill out the paperwork for them to get compensation.
And illegal.
Okay, and illegal. So what are some of the things? And I'm not going to go over all of these things that the vet needs. The big one is the discharge paper, although Bob talked about how to get that discharge paper. It's called the DD-214 or 214. That's a biggie. And if you can't find any of these other papers, go there with just that one or say, I can't find it, and they can look for it. Why is that important? And Bob alluded to this too. So let's say, and we have our service officer there next Tuesday, or you can go up to the county. Let's say somebody goes now with that DD-214 and says, I want to file a claim. And they write that claim down. But then it takes them months to get all of the birth certificates and divorce things and all the other times and different things that they were in. But later, let's say 6, 8, 10 months later, it was determined that they do get compensation. It is retroactive to that day one when they went in there and filed first. And so they can get a lot of retroactive pay from that. So my thoughts on that are get the ball rolling. Don't wait for it. And so in summary, 3 million military men and women served in Vietnam and Korea. There's about 2 million alive now because Vietnam veterans are dying sooner than our World War II vets, too, from a lot of different things. And it's very, very much in the news now about all of the different suicides. Many have been affected by the disastrous consequences of Agent Orange, and their children as well. The VA does not compensate this. They decided back during World War II, let's get all of this money to help our veterans, but they forgot to fund how to advertise it. So I'm advertising it to you, and then you can advertise it to your clients as well. And sometimes it's a long wait for a decision, and you just never know, is it going to be early or quick? Although I do know that if it's World War II vet, they're putting that on the fast track, and they're doing that a lot faster. If it's denied, there's an appeals process. If you go to a veteran and say, I tried that before and it didn't work, I'm not doing it, have them go to a service officer from the county. They are incentivized to get the ball rolling and get more compensation because sometimes other people were not incentivized to have it done. And we can help with the appeals process and how to do it and how to go about it and how to bring your spouse in as well. And again, if awarded compensation, it starts from the first day that you start filing. That's all I have. Thank you.
All right. Thank you, Ina. So Katie's coming up, and she'll give you some instructions for lunch. And maybe we can give them an extra 5 minutes for lunch? Yeah, sure. Okay.
One quick thing, somebody left their top flight wired notebook on our Mannor Law Group table. So if this is yours, I'm going to put it back at the Mannor Law Group table for you to pick up. Make sure if you haven't visited all of the sponsors today that you get your Circle of Care card completed. We are going to be drawing for that soon. We do ask that you be in your seats around 1 o'clock for our next presentation, which is Adam Martin with Martin Funeral Home. It is part of your CE credits, so you should be in your seat for that presentation.